get this. But as this is getting set up, I'm going to be very serious about here the antecedent. And I learned early on in there's kind of a rule. First time when you get burned, shame on you. Second time, if I get burned, shame on me. And so that's why I'm going to ask some very specific questions about how we're going to proceed. And the antecedent to this also is that I hope everybody understands what we're dealing with here. You can put the first one up. Is that we're dealing with something that is one of the most fundamental rights in our society, which is the right to vote. And so when you object to a vote, you are basically saying to a voter, we are going to disenfranchise you because of some reason. Now, Mr. Magnuson, these questions are directed to you. I wish I had there was a nice poster for this seminar. I had it once, and I gave it away, so I don't have the poster. But if you can see up there, you know what I'm referring to. This is the poster or the announcement with respect to the seminar that was held at William Mitchell Law School on the 14th of February. You were there.
I was.
And if I remember in the reports is that with some matter of pride and stepping in the steps of the compliments by the Secretary of State, you presented what you referred to, I think, as your hieroglyphics. If you could put up the next. Are you familiar with this piece of, is that your hieroglyphics from 2 years ago?
That is a record of what that canvassing board decided.
That's for all purposes. I'm not, for evidentiary purposes or whatever. I'm not saying other than to say these are your notes that you explained publicly is how you went about making the decision as to what was the valid vote.
I think most accurately, Justice Anderson, this is a record of what the 5 members of that canvassing board decided on the ballots presented to them.
That's fine. We have one of those members on the board. And I don't know if this thing works. It probably doesn't work. It doesn't work on a TV screen. So I come prepared. If anybody wants copies, I'll give you a copy so you can see. Do you need a copy, Mr. Magnuson?
I think I have it pretty well in mind, Your Honor.
So I mean, and you do believe in precedent, do you not?
Your Honor, I do believe in precedent, and I think that...
Now the question is to what precedent this is, and how valid it is. I mean, you and I have had this discussion around the conference table, how you use precedent. But to the limited extent, you would concede that this is what was used 2 years ago.
This is a record of what that canvassing board's judgment was on these particular matters. And I agree that it provides some guidance as to what this canvassing board might be, but I would hesitate to present an argument to you that you're bound in any way.
Oh, no, I'm not. It is that you know me well enough to know that I wouldn't be bound. But
I meant the entire...
Yeah, but I just want to figure out what this means so I can have some... look at the top there coming down, and I wish we had a pointer, is that... let's go down to the third oval down. That's got an equals OK.
Right.
That's got a little bit of an X on the corner of the oval, and it appears to me you're saying that is OK. You count that.
What I'm saying is that canvassing board decided that was a clear enough indication of a voter's intent to cast a ballot for whomever that oval was next to.
And you voted in favor of this being as part of that canvassing board?
I believe that I did, although not all of our decisions were unanimous. This was a record of the majority votes, as Secretary Ritchie recalls.
Okay, and then you said, and we're going down here, is that you've got, it looks like if it's the oval filled in with an X over the oval, no, you're not going to do that. I'm not.
The X's over and under the ovals were kind of a highlight of the entire experience.
I would say so.
we found that some candidates or some voters would actually mark their ballots initially with an X and then realize they had to fill in the oval. And if we could discern that the oval was filled in over the X, it was that canvassing board's judgment that that was not a strikeout, but that that was a vote. And I might say that this is what I'm anxious to look at in the challenge ballots, because an election official may decide that something that this sheet shows was accepted by the last canvassing board was a frivolous challenge.
Okay, I'm just working through. I'm getting through some more good parts here.
It's snowing like crazy.
I know. I don't care. Is that we're talking about getting a governor in place in time. The next okay I find very intriguing is that the ballot is not completely 100% filled in. Some of the marks are outside of the oval, but that's okay.
Can I just ask a question? You know, it seems to me that we addressed all of the issues.
No, I'm going to go through this, sir, and I have the right to do it because I'm talking about accountability, and I'll get through it in about 5 or 6 minutes.
I just think it might be a good thing for you guys to chat afterward.
No, I'm going to do it publicly. I'm going to do it publicly.
No, we don't talk.
Is it you see an okay where it's a rectangle? You got another okay where there's a little mark, a dash inside the oval? That was okay?
I think that says if others.
If others in the same ballot.
In the same ballot, because that would be a consistent way that the voter was marking the ballot.
And I'm looking down a little bit further. You see where the you've got the oval, and then you got another oval that maybe only covers about 15% of it, but you say that's okay. That's good enough.
You know, I have trouble reading my own handwriting. I can't.
We do too.
We can see it. We can see it.
But it's the one with the equals, and then there's an oval with an X equals okay.
Yeah. And so you know where I'm going with this, Mr. Magnuson.
You know.
And is that if you could show just a couple of those ballots that if you just couple of the ballots of the 84.
If I could show them? Oh.
No, my clerk will take care of that.
Thank you.
These are ballots that came to us as
You know, Justice Anderson, I really understand what you're saying, and I fully recognize our responsibility to discharge our obligations as lawyers and to not make frivolous challenges. If I can look at the ballots,
okay.
I can make a judgment.
And is
my whole point.
And you're not coming to this table without some previous understanding. And I mean, we see as I look at this ballot here, and you can take a look at it. I have a hard time, and I'm not going to go through these. What I want, sir, is one other thing from you. Is that I can put up there the rules of professional responsibility, Rule 3.1, Rule 3.3, A through C.
I would expect that you would have to do that, Your Honor.
I would not expect. But the one I want to focus on is 3.9. And that's the one that says that you're bound by these rules before a non-judiciary tribunal, an executive board, administrative board. Do you see us as the canvassing board where you have those same responsibility under the rules of professional conduct as you would with any executive board, administrative body, or the court?
Absolutely, Your Honor.
Mr. Trimble.
I do as well, Your Honor.
And you understand the consequences of those rules talk about frivolous matters. Do you not?
Yes, I do, Your Honor.
So you're fully aware that the rules of professional conduct say that as lawyers, duly sworn under oath in the state of Minnesota, you will not do anything that's frivolous to any in case before a body such as we are.
That's correct, Your Honor.
Now, I mean, we know there are areas of legitimate disagreement. That's fine.
And, Your Honor, I might also say that it is our job to advocate our client's position.
Within the rules.
Within the rules, and I am happy to do that. I'm also well aware of my ethical obligations, and I'd like a chance to be able to get to these ballots and make some judgments.
And we've given you that chance today. We have done that.
Very much.
And I just want you to know the flip side of it is the conditions that go with it. Is it giving you the chance to look at it? You understand that it's the full, treating us as a tribunal and a body, you're bound not to do something that's frivolous.
I appreciate that.
Mr. Trimble.
In every respect.
Yes, Your Honor. I also want to clarify, I yet to have to see the ballots. I have not reviewed the
I know
ballots,
that's
nor has Mr. Magnuson. And we will do so within the...
I'm just sorry I have to be so persistent on this, because I've looked at some of these and I've been concerned about some of the objections. But if I know that you're on the hook and you're accountable and you accept that...
Well, Your Honor, we've looked at the ballots and we're concerned about them too, which is why we want the opportunity to look at all of them.
I thought I heard Mr. Rogan say that Mr. Trimble was at Hennepin County looking at ballots. Did I mishear him?
Yes, well, if you heard him say that, that would be incorrect. I am there to advise challengers as to questions they may have, but I'm not on the floor looking at ballots per se. My role was to help the other attorneys and help the other challengers. There are 25.
How can you instruct them if you're not looking at the actual ballots?
My primary role, Judge, for Your Honor, is that we are instructing our challengers to make challenges to the best of their ability. We have described which challenges, such as undervotes and overvotes, or identifying marks, which are challengeable. I do not go on the floor and look at each particular ballot that is being challenged or being contested by a table judge. That's not my role.
But you did
That's not the
look
role
at
that I
some
played at
ballots.
Hennepin County. I may have looked at a handful of ballots over the 5 days that I've been there, but I'm not challenging ballots, and nor I'm simply advising challengers as to whether or not they might proceed with the challenge or resolving conflicts between the table judge and a challenger as to whether a challenger might be made.
I don't understand how you can instruct your campaign on what are non-frivolous challenges if you're not actually looking at ballots and saying yes and no to them.
We provided examples to all of our challengers in the training. They all went through the training to some extent. Some did not go through the training. We take the volunteers as they come from day to day, because there are 25 tables in Hennepin, for example. So we have a number of inexperienced people that also show as we run out of people. My job is not to go from table to table to actually view the ballots.
So when you told Justice Anderson that you had not looked at any of the ballots, that was not a true statement.
I have not looked at the ballots to make a challenge. That's correct. That's my response is, am I making challenge determinations with respect to ballots? No, I have not. What I will be doing when we receive copies or when we review in person these frivolous challenges in Hennepin County, that's when we'll sit down and make determinations as to whether or not the challenge will proceed or whether we'll withdraw it as a frivolous challenge.
We don't have enough lawyers to have them do this job. Volunteers have to do it. They went through 800,000 ballots in Hennepin County. The process contemplates that our role comes in when the challenges have been made, then we get the copies and we withdraw the ones that we don't think are justified. I mean, the alternative is to have Mr. Trimble be the one to make the call on all the ballots in the first place, and that's just not possible. And so the process will work if we're allowed to let it work.
And is it, I have some of the same concerns as Judge Riley, but I also understand what you're saying, and that's what this procedure is about today. It's to eliminate, it depends what the definition of is, or Mikey did it. And is it, I'm understanding at the end, what we've done today is you're on the line. You're going to look at them, and if they come to us and we deem they're frivolous, you're on the line.
We understand that.